I'd like to start by thanking the court on behalf of the National Franchise Dealers Association, the NFDA, for this opportunity to set out the position of its members across the United Kingdom. The NFDA accepts, and I say this as a concession, that we're on the wrong side of Parliament Square to be making arguments about economic catastrophe, and we accept that this court's responsibility is the state of the law. And so in considering our role as an intervener, we have in mind a passage from Lord Hoffman's speech in a case called E in the Chief Constable.
We're all familiar with that.
Are you familiar? In the expectation of their fund of knowledge of a particular point of view will enable us to provide you with a more rounded picture than it would otherwise obtain. And so consequently, what we see our position as is helping the court with a better understanding of the role of a motor dealer when introducing finance, rather than arguing the individual merits of these three appeals. In summary, our submission is this. The NFDA robustly rejects the notion that its members have for decades conducted their businesses by accepting bribes. We say that car dealers are the paradigm example of a trader that is understood by the public to be acting in its own interests when dealing with consumers. Nobody goes to a car dealer with a reasonable expectation that it's acting without self-interest in relation to any of the products that it sells, whether that's a car, a roof rack, a maintenance plan, or indeed finance. Consumers expect motor dealers to act commercially for all of the products that they sell. And you don't go to a car dealer expecting financial advice, you go to buy a car. And to that extent, we say that there has been a leap in the law between paid financial advisors and retailers, whose primary objective here is to sell cars. In a short intervention of this nature, we cannot address every issue. So we intend to address you on just three topics, all of which relate to appeal ground 1. The first topic is the role of a car dealer selling a car on finance, and we say that that is commercial throughout. And the way it's been put by others is it's like a stick of Blackpool rock. Commerciality runs all the way through the transaction and the relationship. Secondly, we want to briefly look at the competing tests for fiduciary duty from the perspective of retailers acting as intermediaries in relation to ancillary goods and services. And then finally, we agree with the FCA that this amounts to a sweeping change if the mere act of credit broking now equates with a fiduciary responsibility. And in regard to that, we have a point to make about predictability and stability and how important they are in the development of the law. But can I start with 2 points of background? The focus of these submissions acts on retail credit broking as a part of the sale of goods. And when we say retail credit broking, we see the role as this, introducing the customer to a lender that's willing to lend, conveying information to both the lender and to the customer, and administering the execution of an agreement in accordance with consumer credit laws and regulations. The NFDA's view is that typically credit broking by car dealers is very similar to other retail credit broking in the sale of goods, as happens every day on every high street in the United Kingdom, and perhaps in 2025 of greater significance to the billions of online purchases of goods that are made using credit. And we say that that's quite different to independent fee-paid credit broking, particularly where financial advice is given. A second point is more technical and concerns the modern form of car finance, and it forms some of the background to our points about commerciality. As we know, in the United Kingdom, the majority of cars are bought using finance, and the most common method is a hire purchase arrangement. who the court well understands that the defining feature of a hire purchase arrangement is that the vehicle remains the property of the lender, together with an option to purchase after you've paid all of the instalments. And what we say is significant is that the most common form of hire purchase is called a personal contract purchase, or often referred to as a PCP. I think it's been mentioned thus far. PCP differs from traditional hire purchase because instead of the purchase price at the end being nominal sum, it's set at a higher amount, usually at several £1,000s. So often described as a balloon payment.
I'm sorry?
A balloon payment. It follows there is a relationship between the amount of the monthly payment and the balloon payment. Obviously, a large balloon payment will reduce the amount of the monthly repayments. I'm going to return to that in a moment. So I have 5 points to be made in relation to what we've called our Blackpool Rock submission. Commerciality runs through the entirety of the transaction. The NFDA says that the vehicle and the arrangement of the finance are not distinct and not necessarily sequential. They're part and parcel of one overall transaction. Dealers are selling cars, they're also selling finance. The first point of 5 is that car dealerships advertise and compete with each other not only on price of the car, the cash price of the car, but also on the finance, both in relation to the interest rate and the monthly repayment. And to make good that point, could I ask the court to turn in the hearing bundle and find it first? It's 4029, case of the Crown on the application of Clydesdale Finance and the Financial Ombudsman Service, ex parte Arnold Clark, and the Financial Conduct Authority. And the passage in the judgment of Mr. Justice Kerr from last year that I asked the court to turn to is that 4037 in the hearing bundle, paragraph 13.7. The facts of this case are unimportant. It's really the law in this case is unimportant. It's the factual basis upon which the court considered a judicial review of the Financial Ombudsman's decision to order redress in a motor finance case. And I'll read it.
I think you can take it even judges are familiar with how cars are advertised.
I would like. Well, that will make the next part of my submission easier. So I should read it having referred to it. Arnold Clark's practice at the time was to advertise prominently on its website the APR of 8.9%, using the words low rate finance at 8.9% APR representative, and we're offering the same low APR on all our used cars, with no hidden terms and no unexpected costs. We're so confident in our low rate finance of used car packages that if you find a better deal elsewhere, we'll give you back double the difference. And we say that rather shows that from the outset, the finance is part of the commercial deal and can't be isolated as some partial service. And that is echoed in the way in which cars are advertised by car dealers. And they are not generally now advertised by reference to the cash price of the vehicle. They are frequently advertised by reference to the monthly amount. And those advertisements are almost universal. We see them in newspapers, billboards, the internet, car showrooms, and the windscreens of cars that are on sale. And perhaps importantly, in relation to a question that was raised by my Lord Hodge earlier, is that it is possible to compare the monthly repayment price for a particular vehicle, because on virtually every dealership website, there is the capacity to work out how much the car will cost you if you take it on finance. The second point that we make in relation to that submission is that the experience of NFDA members is that typically when a customer walks through the door of a dealership looking for a car on finance, they are primarily interested in the monthly repayments, not the cash price of the car. The fact that consumers are concerned about finance from the outset is reflected in these appeals. In the witness statement of Ms. Hopcraft, it said, at the outset, I informed them that my intention was to purchase the car through financing. I didn't take the court there. It's in the hearing bundle at 463, paragraph 8. And in Johnson, in the cross-examination, he said that the finance was the first thing he researched when he thought about buying a car. And so we say it follows that firstly, finance is typically discussed before a car has even been selected. And secondly, that often in a consumer's eyes, the monthly finance payments is effectively the price of the car. The third point of 5 is that the finance arrangement has the capacity to affect the type of car that the consumer will buy. What a consumer is willing to pay on a monthly basis is plainly of commercial interest to the dealer. It will inform two things: the selection of a particular vehicle and the choice between a balloon payment hire purchase arrangement or a traditional hire purchase arrangement where the payment at the end is nominal. If a customer opts for a PCP agreement, they are likely to be able to purchase a more expensive car because the monthly instalments are lower and the balloon payment at the end is optional. And so it's often in the commercial interests of a dealer to negotiate on that basis.
So what do you mean by the balloon payment being optional? I mean, you can just decide to wake up one morning and not pay it.
When you come to the end of the agreement,
yes,
you don't have to make the balloon payment.
Oh, I see. You leave the car behind.
Yeah, you just end the car, end the hire.
You either return the car or pay the balloon.
Yes, of course.
Sure.
Yeah, and that what that means is that a significant part of this market is consumers that buy cars on PCP, don't make the balloon payment, make a judgment at the end of the arrangement as to whether or not the car is worth paying for, and simply return the car and either enter into a new arrangement or not. The fourth point follows on from a point that was made by Mr. Howard yesterday, and it was something that was set out in paragraph 1 of the Court of Appeal's judgment. And it is that dealerships will often reduce the price of a car where finance is taken. So, for example, I go to a showroom, I see that a car is on sale for £20,000, if it is on sale in that way, and the dealership will say, well, if you take it on finance, it will be £19,000. And what we say about that is that that is a pretty good indicator that what they are doing has a commercial connotation. The final point in relation to this submission is this. The NFDA's view is that a very significant proportion of transactions, of car transactions, it will be obvious in those transactions, it will be obvious to the consumer that the dealer is affiliated to the lender. Dealerships in a particular make of car will only introduce finance from their affiliate, may only introduce finance from their own affiliated brands. So to avoid being disloyal to any of my clients, I'm going to take an example from yesteryear. Rover cars, or from a Rover dealer, would typically be financed by Rover Finance Limited, sadly another British company that no longer exists. But that model is replicated across the United Kingdom for a wide variety of brands. And so the position is, we say, that that is another indicator that a dealer is self-interested in the sale of vehicles. So that brings me to the end of the points concerning commerciality. The next point concerns profit. And I move to the Court of Appeal's understanding of the commercial nature of the transaction. One of the findings of the Court of Appeal was that consumers would not anticipate that there would be a profit made on the service provided by the dealer in arranging the finance, because they would expect the profit made solely to come from the car itself. I needn't take the court to the passage, but it's in the hearing bundle at 333, paragraph 84. The NFDA questions the logic of that analysis. Motor dealerships sell a range of products and services alongside the sale of a car. Installation of additional products, like tow bars, tyres, etc. Services such as maintenance plans, warranties, and insurance. These are often provided by third parties. And our submission is that the ordinary expectation of consumers going to a dealership is that they would be acting commercially in relation to each of them, including the finance. Arranging finance is a service, and ordinary people understand that companies act commercially in relation to all aspects of their business. Regardless of whether the finance enables the sale, it is still a service which would normally be commercial. So that takes me to the second part of the submission, really the question of whether a motor dealer has a fiduciary role. As we set out in our written submissions, we agree with the appellants that the test for an ad hoc fiduciary duty requires an undertaking of undivided loyalty. And we also agree that a test of whether an intermediary has a role and influence in the decision-making process goes too far. I don't want to be unfair to the respondents' argument, and so I think it's incumbent upon me just to take the court briefly to the passage of the appellant's, the respondent's case, in which that is set out, and that is in the hearing bundle at 210, paragraph 92. And it's the second sentence. But on each set of facts, the law imposes a duty of loyalty because the role and influence that the professional has assumed, so part one, in the principal's decision-making, involves, as it does, an exercise of judgment or discretion, is such to give rise to an opportunity for the agent to promote his own interests, part two, at the expense of the principal, i.e. the risk of corruption. And we want to test that by reference to three examples. These examples are deliberately designed to focus on the retail aspect of a sale of goods on credit. The first example is the example of a kitchen purchase. So it's a common consumer purchase, similar to the value of a car purchase. So for example, a consumer walks into a kitchen showroom to buy kitchen units and appliances. Once the kitchen planning has been done, they agree to purchase the kitchen, and the kitchen company says, we can arrange installation for you. And we can arrange it from our panel of kitchen fitters. I say yes. They make all of the arrangements, including providing the service of passing on the information about the layout of your home, my home in this case, when the installation can take place, and they take payment. and the kitchen company selects the fitter who attends. The installation contract is with the fitter. Now, in those circumstances, there's clearly, we would suggest, no undertaking of undivided loyalty. But it seems pretty clear that the kitchen company would have a role and influence in the customer's decision making, not least by selecting the particular fitter. The second example we give is a high street goods retailer. So, for example, I go to John Lewis to purchase a television. John Lewis has a good reputation. I know that I can take the product back. They promise that they are never knowingly undersold, so I have trust and confidence in them. The sales representative offers me an extended warranty with a television provided by a third party. It's the same point. There's plainly no undertaking of undivided loyalty. Are John Lewis affecting the decision making? Yes, they are. They decide who will provide the guarantee. Is there any element of corruption? I would say no. The final example, closer to the motor dealer scenario. A buyer of a car from a car dealer specialising in classic cars. So I want an E-Type Jaguar, but I'm a cash buyer, and this particular dealer doesn't deal in consumer credit. Instead, sort of a panel of lenders, the dealer says I have various places where I source classic cars. So the scenario is similar, it's not identical. I accept there is one significant difference that I'll come to in a moment. But he says I get cars from a variety of suppliers, manufacturers, other suppliers, auctions. In that scenario, if we take out the element of lending, the dealer does effectively the same thing. He goes out, chooses which car, and provides that car for the customer. Most people would well understand that they were.
Running with this example, do you mean to say that the customer just leaves it to the dealer to deliver a particular classic car to his doorstep?
Yes.
So without ever having previously seen it?
It may well be arranged for the customer to see it. And let me see if I can make the example.
Yes, it's not one that is ringing any bells.
Funnily enough, of the three examples that I had, this was the least favourite of my juniors, but there it is. Let me see, the scenario that we're trying to replicate is of a trader that is seeking out from a range of options a particular deal. In the scenario that where the trader is acting as a car dealer, and as all car dealers do, they select cars from a variety of different sources. In that particular scenario, if you were to go out onto the market and find a car, in those circumstances, could it be said that you had any responsibility to act with undivided loyalty? I appreciate if the example doesn't find favour, I should move on.
Well,
I can see that.
If a customer comes to you and says, get me an MG VGT with a V8 engine, and you go out and select one for him, and bring it back, he still could say, that's not what I want, or that is what I want, but I suppose you could say you've taken part in the decision-making process by giving him the option of purchasing this one.
That was the point I was trying to get to.
Yes. Whether people do that very often in the market, I don't know, but that's the point you're making, I think.
I'm told that I have 5 minutes left, and so I will move back to my final submission. It's about predictability and stability, and I can make it short. On this issue, we agree with the Financial Conduct Authority when it says in its written submissions that this is a sweeping change. If merely acting as a credit broker in the sale of goods is the equivalent of an undertaking to act as a fiduciary. As the national regulator of credit brokers, it had never understood credit brokers without more to have fiduciary duties. And Mr. Howard took you back to the 1960s report of the Law Reform Committee, which made clear that commission reward was a normal and expected part of the hire purchase transaction. The NFDA and its predecessor, the retail motor industry, go back to 1914, and we would say that for over 100 years, it's been well known, understood, and accepted that commission was a normal part of hire purchase and not a corrupt practice. We agree with the FCA that it's in the public interest that the common law should develop incrementally or predictably. There is otherwise a real danger of uncertainty of the kind that will lead to lenders refusing to lend and brokers refusing to sell cars on finance. I did have some further points to make in relation to the uncertainty created by duties to find at least a competitive offer of finance and carry out necessary negotiations, but they are set out fairly fully in our written submissions. So unless I can assist the court further, these are the submissions that I have.
Thank you very much, Mr. Kirk. We're grateful for the association's assistance.